A new U.S. immigration law was passed today, and if you hold a green card or you are working toward one, this is not something you can afford to ignore. On the surface, it looks like good news, even long overdue progress. But beneath that headline is a split reality. For some people, this law opens doors that have been locked for years. For others, it quietly introduces new rules that could cause serious trouble if they are missed. What makes this moment so important is not just what changed, but how fast it is happening. There are benefits that kick in quickly, requirements that begin soon, and decisions you make in the next few months could shape your entire future in the United States. Many people will hear about this law too late, after deadlines pass, or after a simple oversight turns into a problem. That is why you need to understand this now, not later. Today's law is not speculation. It is not a proposal, and it is not political noise. It is real. It is passed, and it applies to millions of people right now. Some green card holders will finally see relief after years of waiting. Others may not realize that habits they have had for years are now being scrutinized more closely. And there is one specific requirement buried in this law that almost everyone will be subject to whether they realize it or not. If you find this video helpful, please hit the subscribe button, turn on notifications, and give it a like so you never miss important updates delivered straight to your smartphone. Now, let us get into the video. Welcome to U.S. Immigration Info, your trusted source for accurate, verified, and timely immigration news that actually matters to your life. Today's update is one of the most important we have covered in a long time because it touches nearly every category: green card holders, people waiting in backlogs, workers on temporary visas, and families who have been living with uncertainty for years. This new law is not just about speeding things up or tightening rules. It is about redefining how the U.S. immigration system expects people to live, work, and stay connected to the country. The implications of this legislation extend far beyond what most news headlines will tell you, and understanding the full picture is essential for anyone whose life depends on maintaining legal status in the United States. In the next few minutes, we will walk you through what changed, who benefits immediately, who needs to be more careful than before, and what actions you should start thinking about right now. No panic, no exaggeration, just clarity so you can move forward with confidence and make informed decisions about your future. Let us start with one of the biggest and most positive shifts this law brings, especially for people who have been stuck waiting far longer than they ever expected. For years, employment-based green card applicants have lived in a state of limbo, watching priority dates crawl forward while careers, families, and life plans stayed on pause. The frustration has been immense, with talented professionals spending decades in uncertainty, unable to change jobs freely, unable to start businesses, and unable to plan for their futures with any degree of certainty. This new law directly targets that pain point and offers something that has been missing from the immigration system for far too long: accountability and deadlines. One of the most impactful changes is a legally mandated processing timeline for most employment-based green card applications. Under this law, immigration authorities are now required to process these cases within 180 days. That alone is a dramatic shift from the multi-year uncertainty many people have endured. Think about what this means in practical terms. Instead of filing an application and then waiting years without any clear timeline or expectation, applicants will now have a legal right to expect a decision within 6 months. This fundamentally changes the relationship between applicants and the immigration system. To make this possible, the government is allocating new funding to hire additional immigration officers, modernize systems, and finally move away from outdated, paper-heavy workflows that caused so many delays in the past. The investment is substantial, with hundreds of millions of dollars being directed toward hiring, training, and technology upgrades that will bring USCIS into the modern era. For years, immigration advocates and policy experts have pointed out that the agency was severely understaffed and working with technology that was decades behind the private sector. This law finally addresses those concerns in a meaningful way. What this means in real life is momentum. If you are on an H-1B visa, if you have been waiting on an I-140 or adjustment of status, or if your priority date has felt permanently frozen, this law could significantly shorten your wait. The sense of hopelessness that has pervaded the employment-based immigration system for so long may finally begin to lift as these reforms take effect. There is also a major expansion of premium processing that deserves attention. Until now, premium processing was mostly limited to temporary visas or extensions, allowing applicants to pay an additional fee for faster adjudication of their cases. Under this new law, certain green card stages can now be expedited as well, potentially delivering decisions in as little as 30 to 45 days for those who choose that option. This is a game changer for applicants who have time-sensitive needs, whether related to employment, family circumstances, or other life events that require certainty. The premium processing expansion also signals that the government recognizes the value of offering tiered service levels to meet different applicant needs. This does not mean everyone will be approved instantly, and details are still being rolled out through agency guidance and implementing regulations. But the direction is unmistakable. The backlog crisis has been acknowledged at the legislative level, and action is finally being taken. For applicants from countries that have historically faced the longest waits, especially India and China, this is a long-awaited signal that patience is no longer being ignored. Relief may not come overnight, but for the first time in years, there is a clear sense that the line is actually moving and that the government is committed to addressing the structural problems that created these backlogs in the first place. However, while this law brings speed and opportunity for many applicants, it also draws a firmer line for people who already hold green cards. If you are a permanent resident, this part is especially important to understand because it could directly affect your ability to maintain your status. The new law introduces stricter scrutiny around how much time green card holders spend outside the United States. In the past, many people believed that returning to the U.S. once a year was enough to stay safe. Under this new legislation, that assumption no longer holds. The government is sending a clear message that permanent residence means exactly what it says: permanent residence in the United States, not occasional visits while living primarily abroad. If you spend more than 6 months outside the U.S. without a re-entry permit, your case can now be flagged for review. This is not an automatic loss of status, but it does mean that you will face additional scrutiny when you return, and you will need to be prepared to explain your absence and demonstrate your continuing ties to the United States. If you remain outside for more than a year, you could face serious risk of losing your permanent resident status unless you can clearly prove strong ties to the United States. These ties include things like full-time employment in the United States, property ownership such as a home or real estate, close family members who live in the U.S., including spouses and children, and consistent tax filings that demonstrate you are treating the United States as your permanent home. The government is making it clear that a green card is meant for people who actually reside in the United States, not those who treat it as a long-term travel document that allows unlimited stays abroad. This shift reflects a broader policy perspective that permanent residence is a privilege that comes with responsibilities, not just benefits. There is also a new compliance requirement that many people might overlook because it seems minor, but it could have significant consequences if ignored. Green card holders will now be required to file a simple yearly confirmation of residence online. It takes only a few minutes to complete, but missing it could trigger unnecessary problems with your status. The system will send reminders, but ultimately the responsibility falls on each green card holder to ensure they complete this requirement on time. This may sound stressful at first, especially for people who have held their green cards for years without any ongoing reporting requirements. But it is important to keep perspective. If you live in the U.S., work here, pay taxes, and genuinely maintain your life in this country, this law is not aimed at you. It is designed to prevent misuse by people who obtain green cards but never actually establish residence in the United States, not to punish real residents who are doing everything right. The key takeaway is awareness. Habits that were once casually accepted now matter more than ever before. Long trips abroad that used to raise no concerns may now require more careful planning and documentation. And staying informed and compliant is the best protection you have against unnecessary complications. If you are a green card holder who travels frequently for work or family reasons, now is the time to review your travel patterns, gather documentation of your U.S. ties, and ensure that you are prepared to demonstrate your commitment to residing in the United States if questions arise. Now let us talk about one of the most exciting parts of this new law, especially if you work in healthcare, because this change is not small and it is not symbolic. It is a direct response to a national crisis that has been building for years and reached acute levels during recent public health emergencies. The United States is facing a severe shortage of healthcare workers at every level, from physicians and nurses to home health aides and medical technicians. Hospitals are struggling to fill positions. Rural areas have been particularly hard hit, with some communities losing access to basic medical care because there simply are not enough healthcare workers to go around. And this law finally turns that reality into action by creating pathways for the healthcare workers this country desperately needs. Under the new provisions, nurses, doctors, medical assistants, therapists, physical therapists, occupational therapists, home health aides, and several other healthcare professionals now have access to a fast-track pathway to permanent residency. If you have been working in the U.S. on a temporary visa in a healthcare role, you may now be able to apply for a green card without going through the long and exhausting labor certification process that used to slow everything down. The PERM labor certification process, which requires employers to demonstrate that no qualified U.S. workers are available for a position, has been a major bottleneck for healthcare workers seeking green cards. This law eliminates that requirement for qualifying healthcare professionals, recognizing that the shortage is so severe that requiring employers to go through this time-consuming process makes no practical sense. On top of that, the law creates a special visa allocation just for healthcare workers, adding 25,000 green cards every year outside of the usual caps that limit employment-based immigration. That means less competition with applicants in other fields, faster decisions, and more certainty about timelines. These additional green cards are specifically reserved for healthcare workers and cannot be used by applicants in other categories, ensuring that healthcare professionals will actually benefit from this allocation. This is especially meaningful for healthcare professionals from countries like the Philippines, India, Pakistan, Nigeria, Ghana, Jamaica, and many others who have kept hospitals, clinics, nursing homes, and care facilities running during some of the most difficult years in recent history. These workers have been on the front lines, often working long hours in dangerous conditions, and this law represents a recognition of their contributions and a commitment to ensuring they can build their futures in the United States. The message from the government is clear: your work matters, and they want you to stay. Just as important, this law includes new protections against exploitation that have been desperately needed in the healthcare sector. Employers can no longer use immigration status as leverage to underpay or mistreat healthcare workers. Fair wages and proper working conditions are now part of the legal framework, with penalties for employers who violate these requirements. Workers will have the ability to report violations without fear that their immigration status will be used against them. If you are in healthcare, this is not just an opportunity. It is a turning point that could define the next chapter of your life in America. Start organizing your documents, understand your eligibility criteria, review your work history and credentials, and seek proper guidance from qualified immigration professionals, because this window may move faster than many people expect. The demand for healthcare workers is not going away, and this law creates a clear pathway for those who are ready to take advantage of it. But while this law opens doors in powerful ways for many applicants, it also brings back a rule that has many people worried, and understandably so. The public charge rule has been reinstated and strengthened. which means immigration officers will now place more weight on financial self-sufficiency when reviewing green card applications and renewals. This rule has a complicated history, having been implemented, challenged in court, blocked, and modified multiple times over the years. The version included in this new law represents a more comprehensive and legally durable approach that is likely to remain in effect for the foreseeable future. Understanding how this rule works and how to position yourself favorably is essential for anyone currently in the green card process or planning to apply in the future. This does not mean that using public benefits automatically disqualifies you from getting a green card. That is a critical distinction that often gets lost in the fear and confusion surrounding this rule. If you have needed help because of a medical emergency, a temporary job loss, a family crisis, or other difficult circumstances, brief use of assistance will not destroy your case. The law recognizes that everyone goes through difficult times and that temporary reliance on public support does not make someone a bad candidate for permanent residence. What the law focuses on is long-term dependency. If someone has relied on certain public benefits like Medicaid, food assistance through programs like SNAP, or housing support through Section 8 or other programs for more than 12 months within a 3-year period, their application may face closer scrutiny. Officers will look at the full picture of your circumstances, including whether you are employed and earning income, whether you have savings or assets, whether you have family members who can support you, your age and health status, and whether you can reasonably support yourself and your family moving forward without relying on public assistance. This shift can feel intimidating, especially for families who have struggled financially or who needed help during the pandemic years. But it is not meant to punish people who went through hard times. It is meant to prioritize applicants who demonstrate stability and independence and who are likely to contribute economically to the United States, rather than requiring ongoing government support. If you are planning to apply for a green card or adjust your status in the coming months or years, now is the time to be intentional about how you present your financial situation. Focus on consistent employment, even if it is modest income. Build savings where possible. Even small amounts demonstrate financial responsibility. File taxes correctly and on time, as this creates a record of your economic participation. Show contribution to your community and the economy, not perfection. This standard is tougher than before, but it is manageable with preparation and awareness. The goal here is not fear, but readiness. Understanding what officers are looking for allows you to present your case in the strongest possible light. For many families, this next part of the law is the most emotional because it finally brings certainty where there has been none for decades. The new law creates a permanent legal pathway for dreamers. People who were brought to the United States as children, grew up here, went to school here, learned English here, made friends here, and built their entire lives here, yet have lived year after year with uncertainty about whether they would be allowed to stay. These young people, many now adults with careers and families of their own, have been caught in a legal limbo that has affected every aspect of their lives. They could not plan for the future because they did not know if they would have a future in the only country they have ever really known. Under this legislation, eligible dreamers who meet clear criteria can now apply directly for green cards without going through other immigration categories. The criteria include continuous residence in the United States for a specified period, no serious criminal history that would disqualify them, and either education such as a high school diploma or equivalent, employment demonstrating economic contribution, or military service showing commitment to the country. This is not temporary protection like DACA, which had to be renewed every 2 years and was constantly under legal threat. This is permanent legal status that provides the stability dreamers have been seeking for so long. For the first time, dreamers are being offered stability instead of survival. They can plan for careers, buy homes, start businesses, and build families without the constant fear that their status could be revoked by a court decision or a change in administration. The law also goes a step further by allowing approved dreamers to sponsor certain family members, opening a path for parents, siblings, and spouses who have been separated by legal barriers for years. This recognition that dreamers have families and that those families also deserve consideration is an important acknowledgement of the human dimension of immigration policy. Processing for these cases will be prioritized with a target timeline of about 12 months, reflecting the urgency of providing relief to a population that has waited long enough. There is even financial assistance available to help cover application fees, recognizing that many dreamers were blocked from higher-paying opportunities simply because of their status and may have limited resources to pay the costs of the application process. This is a moment of long overdue recognition. The message is powerful and clear. If you grew up here, contributed here, followed the rules, and made this country your home, you belong here. America is finally saying that you are not a guest or a temporary presence, but a member of this society with the same rights and opportunities as anyone else. If you are a dreamer watching this law is not just a policy update. It is a turning point in your life and the lives of millions of others who share your situation. Preparation matters, documentation matters, and guidance matters. Gather your records showing continuous residence. Compile your educational and employment history. Understand the criteria and ensure you meet them. But for the first time, the path in front of you is real, stable, and achievable. The future you have been hoping for is finally within reach. Now, let us shift to another group that this law directly empowers: entrepreneurs, innovators, and job creators who have ideas, energy, and capital, but have struggled to find a place in the traditional immigration system. For years, talented founders were forced to leave the United States not because their ideas failed, but because the immigration system had no clear place for them. Someone could start a company, raise millions in funding, create dozens of jobs for American workers, and still face deportation because they did not fit into existing visa categories designed for employees rather than founders. That changes with this new law in a dramatic way. A groundbreaking startup visa program has been introduced, allowing foreign entrepreneurs to apply for green cards if their businesses are actively contributing to the U.S. economy. If you founded a startup in the United States, raised at least $250,000 from qualified investors, such as venture capital firms or angel investors, and created a minimum of 5 full-time jobs for U.S. workers, you may now qualify for permanent residency without relying on employer sponsorship. This is a major shift from the previous system where entrepreneurs had to find creative workarounds or leave the country to operate their businesses from abroad. It recognizes that innovation does not always fit into traditional employment categories, and that the people who create jobs are just as valuable to the economy as those who fill them. The law also expands and adjusts the investor visa program, lowering the minimum investment requirement in certain rural or high unemployment areas to $500,000, making it more accessible to families who want to invest, build, and grow in the U.S. economy, but do not have millions of dollars to commit. At the same time, the law strengthens fraud protections to ensure only legitimate businesses and investments qualify, protecting both applicants and the integrity of the system itself. This is not about buying status through paper investments. It is about building real value and contributing meaningfully to American economic growth. If you are an entrepreneur, a founder, or an investor with a serious vision for building something in the United States, this law is an invitation. It rewards initiative, job creation, and long-term commitment to the American economy. The opportunity is real, but so is the responsibility that comes with it. Strong planning, real impact, and proper documentation will be essential for those ready to take that step. The door that was once closed is now open for those willing to put in the work. There is one final change in this new law that applies to everyone, no matter how you obtained your green card, and it is something you will need to stay on top of going forward for as long as you remain a permanent resident. Starting 6 months from now, all green card holders will be required to complete a biometric renewal process every 10 years. This includes updated fingerprints, a new photograph, and iris scans that will be stored in secure government databases. The purpose behind this is not punishment or control or surveillance. It is modernization and security. The government is working to eliminate outdated records, reduce identity fraud, and ensure that permanent resident documentation reflects who you are today, not who you were decades ago when you first received your green card. The process itself is straightforward and should not cause anxiety. When it is time to renew, you will be scheduled for a visit at a USCIS application support center. Most appointments take under 30 minutes, and the staff are trained to process these renewals efficiently. What is important is that it is mandatory. Missing it or ignoring renewal notices could create unnecessary complications even if your underlying status has not changed. The government will send reminders, but ultimately responsibility falls on each individual to comply. Along with this, the law introduces a digital green card component that reflects how documentation is evolving in the modern era. You will still receive a physical card that you can carry in your wallet, but you will also have access to a secure digital version through a government app. This digital card can be used for employment verification, identity confirmation, and certain travel-related processes. It is encrypted, protected by multiple security layers, and designed to make everyday interactions simpler while reducing the risk of fraud or counterfeiting. That is all we have for this bulletin. U.S. Immigration Info Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas, such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you have not already, please subscribe to U.S. Immigration Info Channel. Thank you for watching, and we will see you in the next video.